Ethical Perspectives on the News is produced by the Interreligious Council of Linn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Hi, I'm Beth Parker, and thank you for joining us on Ethical Perspectives. After viewing all the discord in the news and on the streets, it's apparent that we have significant differences. We also share many commonalities. We are all more alike than different in significant ways. For example, we share common interests in the laws that define our society and culture. Policymakers, legislators, and politicians are critically important because they determine the laws, rules, and regulations set to maintain social order. Of all such policymakers, the Supreme Court has of late come under particular scrutiny. Let's see what we can find out about the Supreme Court, whose lifetime appointees will guide the American nation well into the future. I'll ask our panelists, please, to introduce themselves and tell us why this is an important discussion. And Tim, why don't we start with you?
I'm Tim Hagle. I'm a political scientist at the University of Iowa.
Yes, my name is Diehl. I come here in the capacity of being the president of the Interreligious Council of Linn County, also the vice president of the Humanists of Linn County, and a frequent moderator of the Ethical Perspectives on the News. But I am really interested in this topic in my capacity with the Interreligious Council and Humanists of Linn County as it pertains to just, the separation of powers that, our system of government is based upon, and the importance of the separation of church and state. So that's why it's of interest to me. Thank you.
Steve Pace. I'm an attorney at Shuttleworth and Ingersoll. I am a member of the U.S. Supreme Court Bar, so I'm admitted to practice before that august body, and also the federal courts, and then an Iowa Supreme Court. So the courts are one of our branches of government, and it's one of the three. So it's extremely important that the courts are viable and that people believe that the courts are fair and that they're representing the correct approach to the cases they're deciding. So I think it's important for that reason too.
So much to talk about here. Let's talk about the intended purpose of the Supreme Court. Anyone would like to start with that conversation?
Well, I guess I can start on that one. If you want to look back at the Constitution, of course, and we talk about, as Steve was just mentioning, three branches of government. And when you look at the Constitution and read it, the three first articles deal with the three branches of government. And the longest one is Article 1, deals with Congress, has lots of do's and don'ts, especially on the don't side. Article 2 deals with the executive branch, the president, and so forth. And Article 3 deals with the judiciary. And the interesting thing is that it's the shortest of the three, that the founders didn't seem to have a whole lot to say about it. And at least one person back then, I don't recall who it was, but termed it the least dangerous branch, that they really didn't give it a whole lot of thought. And it wasn't until a number of years later, in the very early 1800s, in a case by the name of Marbury versus Madison, which is fairly famous, where the Supreme Court took upon itself the duty of judicial review, which is to say that they would be able to look at executive actions and legislative enactments and decide whether they were consistent with the Constitution. And so that's sort of where it began, where the courts are the ones that determine whether something is in line with the current Constitution and its amendments.
And Beth, the purpose of the court, it's the final decider. I mean, the U.S. Supreme Court they decide cases. And so it could be a case between two states. It could be a case involving private individuals that's come up through the federal system and has been appealed to them. It could be from a state Supreme Court, and that would be under the certiorari rules. The Supreme Court of the United States can take cases from state Supreme Courts. It can be about a federal election. It can be about lots of different things. One of their purposes is to interpret the Constitution. But it isn't correct to say that all of their cases involve constitutional interpretation. Many of them do not. That's one of their jobs and one of the purposes, but not the sole one, certainly.
Yeah, I think I'm not a constitutional scholar or Supreme Court scholar, but I do feel as as our as our society has become larger, more complex, in modernity, that the need for interpreting the Constitution and all the laws that kind of have disseminated from it is extremely important, right? We need a kind of a final arbiter in that, and certainly, again, making sure that when we have enacted laws, whether that be from the executive or legislative branch, that violate the fundamentals of the Constitution, we do need people with expertise, people without bias, as much as you can have that, to have an objective view of whether these laws violate what our country was founded upon. So I think the Supreme Court should be valued for what it is. We need to appreciate its integrity, maintain its integrity. When we feel like the Supreme Court, or any court for that matter, has been corrupted by anything, we should definitely get to the bottom of that. And because it's very, very important that we have that we're caretakers of our laws, and we have people whose full-time job it is to do that thing.
So, Attorney Pace and also Mr. Hagle, Professor Hagle, I want to just stop a second and ask about so there is no greater arbiter than the Supreme Court, right? There is no appeal. You can't, if that's the final decision, the end, period, there's no, how do you correct if the Supreme Court makes a mistake? That just came to my mind because of something you said. Is there a way to override the Supreme Court? And I think you're saying no.
Well, there is, but it's extremely rare, and it will depend on the type of situation. Now, as Steve was indicating, that one of the main jobs, or one of the things that the Supreme Court or federal courts more generally do, is interpret statutes. And it's not necessarily with respect to whether it's constitutional or not, but just basically what did the legislature mean when they wrote whatever it is that's in a statute. And quite often, legislation is not the clearest, and so judges sometimes have a difficult time figuring out what they meant, or what some regulation meant, or something along those lines. So if the Congress doesn't like how a bit of legislation was interpreted, they can always change it. They can rewrite the legislation and do something along those lines. As far as constitutional interpretation, the only recourse really is to pass a constitutional amendment. Now, again, there may be ways that the legislature can tinker with things. If some bit of legislation is considered unconstitutional, maybe they can come back and find a way around whatever the problem was, fix it, and so forth. But if it's a flat out something like, okay, you can't do this because it's unconstitutional, the only thing that can really happen is to pass a constitutional amendment. And that's only happened 4 times in our history, so it's very difficult to do. The only other thing that could happen, and this is sort of the long-term strategy, which sort of came to the fore in this term, is that over time you may have changes in personnel on the court, and that may cause the justices at any particular point in time to change their mind on some previously decided case.
Thank you.
That's right. And you could change the number of Supreme Court justices. That's not set in the Constitution. It's set by Congress. And the last time they set it was, I think, 1869. There was an act passed, and it set the number at 9. It's been as few as 5 and as many as 10. Originally, it was 6. Now it's 9. And there was actually a statute that was introduced in 21 to increase the number of justices to 13. It didn't pass. So I don't know, but I suppose one thing that could be done would be to increase the number of, or decrease the number of justices. That's been talked about over time, but I don't think, Professor Hagle, they've really been talked about seriously. And since maybe the Roosevelt years, there was a talk of packing the court, expanding the court to get more people on that might agree with the administration. I don't think that went anywhere either.
Okay, well, interesting. Let's go back to some things about the change in the Supreme Court. We were talking about the original intent of the Supreme Court, but is that changing? What has changed, and how has the Supreme Court modeled or molded or evolved in their role now?
Well, one of the things that's probably changed over time is the reliance on, and it's not just the Supreme Court, the federal courts in general, relying on them to make these kinds of decisions. That early on, the Supreme Court didn't have its own building. It was meeting on an irregular basis. The justices had to what was called ride circuit, where they actually served as what would now be called Court of Appeals judges, but they had to sort of serve that as well. And they met once in a while to do their Supreme Court stuff. But over time, as the legislatures became more active and as people began to rely on the courts to overturn certain types of legislation, and here I'm thinking a lot of the discriminatory legislation with that, in particular, the NAACP and Thurgood Marshall, who was a lead attorney there, that were bringing to try to overturn a lot of Jim Crow laws and so forth, that people began to rely on the courts to overturn these types of laws. And that's continued through the modern era, where basically we're relying on the court for a lot more decision making than was originally the case. And to kind of go back or tie this back to some of the things we talked about before, the Supreme Court may be the ultimate decider on a lot of these issues when they actually accept a case. Something on the order of about 8,000 cases are filed before the Supreme Court every year, and they only decide to take about 100 where they give a full opinion and argument for, maybe another couple of hundred that they decide summarily, just to say affirm, reverse, or something like that. And so it's a very small percentage of cases that are filed that they actually get to decide on. And so that means that the courts of appeals, federal courts of appeals, or the state Supreme Courts are really the ones that make the bulk of these decisions. And so even though we're focusing on the Supreme Court, and understandably so, we have to also be thinking that the judges in the lower courts are particularly important as well.
So is this a good time to talk about judicial activism? I think you brought that up.
Yeah, let's go back, if we would, just for a minute to a prior time, because there was a lot of talk about that during the time of the Warren Court, Earl Warren, when he was Chief Justice, and he was from 53 to 69, and it was considered to be by some an activist court. There were many very important decisions that came down during that time. One was Brown versus the Board of Education, which schools were segregated up to that time, and then because of that decision, integrated. It was a huge turning point in American history, and that has remained. And that was a overruling, by the way, of a prior case, P.L.C. versus Ferguson, which was separate but equal. And so that separate schools were no longer going to be allowed; they're going to be integrated. That was a huge thing, and Earl Warren was a very conservative person, appointed by a conservative president, Eisenhower, but he presided over that case, the Miranda case, where we see on TV all of the, you have the right to remain silent, all those warnings that people get. That wasn't the case before Miranda. That was in 1966. Loving versus Virginia was in 67. Up until that time, Virginia had a law that said white people and black people could not be married. Unbelievable. In 1967, I guess we'd say now, but that was true then. And so they said you can't do that. You can't have a law that says that. And so all I'm saying is during that time, there were many in the country that didn't agree with those decisions. And so there was talk about, is the court changing? Are they influenced by politics? Is this an activist court? And so that sort of a debate has continued. Now it's starting up again in a different context, I guess I'd say, because of the Dobbs case.
Right? So is politicization the same as activist? Are those two terms equitable in terms of this conversation? The politicization?
Professor, I don't know. It depends on what side you're on. I guess whether you think these are activist judges or whether this is a political thing or not a political thing.
Yeah, I think we were talking to that before the show, right? So as a layman myself, when it comes to the Supreme Court and its history, learning a lot just being on this episode, that, it really does depend, right? So if you're on the left-hand side of things, the political spectrum, and the Supreme Court rules in a kind of from a conservative majority, or if you're on the conservative side of the spectrum and they rule from a liberal majority, you can kind of blame it on activism or politicization. And I think, again, the goal should be, and I think several justices have tried to be explicit about that there are no, Republicans or Democrats or conservative or liberal judges, or at least there should not be. However, I don't know for sure how you, in today's kind of partisan, hyper divided political atmosphere we find ourselves in, how the court fully kind of makes themselves immune to that accusation. I'd be interested to hear. I mean, certainly, there's been instances, right, in which quote unquote conservative judges have ruled in a more liberal fashion, and vice versa. And to be honest with you, myself, I find that quite refreshing. And I hope that people, when they see that, take that to heart, and certainly don't just go with confirmation bias, meaning, we're gonna look to where anytime they may have sided with the left or right. So I think there's instances of that, but yeah, I'm interested to get my fellow panelists' thoughts on how the Supreme Court kind of makes them immune to that accusation of being partisan in their rulings.
If I could just add something real quick, Federalist 78, which was the Federalist Papers clear back. Why do they have lifetime appointments for Supreme Court justices? And Federalist 78 says that they did that to secure a steady, upright, and impartial administration of the laws. And what that meant was so they would not be influenced by political determinations and disagreements. And so that, if you go back to what the founding fathers or our founders want, they wanted to have judges and justices that were not influenced by the prevailing winds, but would decide cases fairly and impartially. And so, that's why they did the lifetime appointments. Now, there's some folks that say they don't like that anymore either, but and we can get into that if you'd like.
Yeah, I'm interested in, I think just again what I had said there, that how do we kind of reassure people? How does the Supreme Court reassure people that there is no, that we're not ruling because we were appointed by Barack Obama or Donald Trump or any particular administration, right? But we are coming at it in many instances with 20 or 30 or years of a judicial experience, and we understand the importance of being able to look at a legal document or a legal decision objectively without not through the lens of my particular political ideology. And I think people hopefully need to be reassured that we do have an independent judiciary. And so I'd be interested in Tim, your thoughts, right, on how they can reassure people.
Yeah, it's a tough question. We brought up in that sort of dialogue there are a number of different issues going on. And I'd start with maybe Beth's initial question, which is that, and I think Alan was kind of hitting on this, where judicial activism is one of those things that's usually seen as a negative. And so if the decision is not the one you want, this is judicial activism. But if it's something you like, it's, well, that's the law and so forth. And so in some sense, you can't get away from that. Now, when presidents make their choices, when there's a Supreme Court vacancy, they're usually looking for a particular type of justice, somebody who may be conservative if it's a Republican president, liberal if it's a Democratic president, and so forth. And to some extent, that's what the voters want when they pick, especially these days, when they pick a president, somebody who's going to fill a certain slot. And then sometimes that's when you see the big fights on the court, is when maybe somebody that was a liberal like Ginsburg is replaced by somebody who's a conservative like Barrett. And that's when you see the big fights, especially if you have some close decisions that have been coming down. Let me also say that one of the things that those of us that study the Supreme Court, and that is my main area, is that the vast majority of the cases that the Supreme Court decides are either unanimous or like 8-1 or something like that. And it's only really the big decisions that will get those heavily divided votes, 5-4, maybe 6-3, something like that. But of course, those are the ones that get the attention. But one of the things that I often tell my students, and I teach an undergraduate course in constitutional law, is that they have a general idea as to certain justices will tend to be conservative, certain justices tend to be liberal, and we would expect them to vote that way. But the really interesting situation is when you have the justices don't vote the way you would expect them. And the case I always tell them about was a flag burning case from 30 odd years ago, Texas versus Johnson, where Stevens was considered a liberal, was upholding the protection of the flag, and Scalia, the conservative, was saying, no, it's free speech. And so that's kind of an interesting case. And to kind of get one more point in here, and that the way that the justices can basically justify their legitimacy, regardless of whatever the decision is, whether it's liberal and people like it or conservative and people like it, is to write good opinions. That if they're basing their opinions on a clear argumentation, following precedent, at least the way they see it. Now, again, the justices will disagree on the meaning of precedent and how it should apply. But if they're basically going back and saying, this is why we're doing it, if they can give a good explanation, that helps. That may not solve all the political problems, but at least it helps in terms of showing that, look, we have a legitimate reason for deciding the way we do.
Yeah, I think that's a great point. With the most, recent rulings that have been well talked about, and I've asked a couple different people, did you read the opinions, that were given, both the dissent and and the positive, and in most cases, no. There's just a jump to an assumption that no, they just came to that arbitrarily because of political pressure or whatever. And it's like, well, I do think it's helpful, even when you disagree with the opinion, to at least get into the mind of that justice and be able to understand kind of the the rationale for why they came to it. And I think it's helpful, right, to be able to humanize that person and don't just think of them as a tool, which is very easy to do, especially when you disagree with their decision. So I think that's great.
So, I mean, it's interesting to me that bottom line, we are all human. And so I don't know where you get to that point of objectivity. There's something about our background, our culture, our heritage, our beliefs that's always going to weigh in. And so I guess that's really hard for me to understand. How do you know when there is a non-subjective or an objective judge? We are kind of running out of time, but I want to ask, do you have faith in the Supreme Court? Are they moving in the right direction? Are you confident in their decisions and in their rulings and in their demeanor?
Well, I do. Again, I practice before the bar of the Supreme Court, so it would be unwise and incorrect for me to be critical of them. They said in the Dobbs decision, this is not a political decision. We're not deciding this on for political reasons because we have a preconceived notion. They said that they thought that the Roe case was wrongly decided. I have a little background in that case because Randy Bezanson was my constitutional law professor. He was the clerk for Justice Blackmun and was there when the Roe decision was decided. And, people were a little surprised by somebody like Blackmun, who was again appointed by a conservative president, writing that decision. But, he decided there was a right to privacy under the Due Process Clause, and this court's decided that wasn't correct. And they have a difference of opinion, and the precedent was overruled. So the opinion is fairly well written, I think. Getting to the point that we were making earlier, it's 120 some pages, so you have to stick with it. But if people do not have faith in the Supreme Court, ultimately we're going to have a problem in our country, because who decides? If in Bush versus Gore, people said we're not going by the Supreme Court's decision, what would have happened if Vice President Gore would have said, okay, the Supreme Court has spoken? I don't know.
Yeah, I mean, the alternative,
we have a real problem if we don't have a final arbiter.
Yeah, that's right, and that's the point I was making earlier, right? I mean, otherwise it's mob rule, I guess, right? The strongest survive, or so we it's the best of the worst options, right? In that, yes, but we're also not just appointing people off the street, right? These are people that are highly credentialed, that have a lot of experience, that certainly are well qualified, and we have a screening process, a process by which we, make sure that we're appointing the best of the best. And so we have to trust the system in that sense. And yes, it's not always going to, the decisions are not always going to be what we want. But we have to respect what we've built in this country, right? Our system of laws, our system of government, and realize that for 200 plus years it's worked pretty well, and we can only hope for the best in the future. So yeah, you gotta continue to have faith in it, for sure, in my opinion.
So I guess we better consider closing arguments here. And Professor
right.
and attorney, what are your final comments, and what do you want us viewers to take from this conversation, as far as learning more about the Supreme Court, as far as understanding their definition and their role and how they're performing? What closing thoughts would you leave us with?
Well, the closing thought I'd leave with is sort of follow up on what Alan was just saying, is that, even if you disagree with the opinion, you have to respect the institution. And one of the things that would help in that regard is when some of the folks in the other branches of government, whether it's the administration or the legislative branches, don't try to tear down the court just when they don't like that opinion. Find ways to change the law, change the ruling, do something different, but don't attack the court.
Yeah, again, I think it's very important that people respect the court's decisions, because if they don't, we don't really have any option for that third branch of government. So it's extremely important. And over the years, the court has tried to make very careful decisions so that people will be believing that they're doing it correctly, impartially, fairly. You don't always agree, but the pendulum swings back and forth. So at this point, they're what we have, and I think they're trying their best. I certainly hope so.
Yeah, and I know we just have a couple minutes left, and I would just say, absolutely. I think respecting the court's decision is not the same as agreeing with it, right? You can vehemently disagree with it, be very upset by it, but that you still should respect it and respect the process and follow the channels that we have as citizens of the United States and as voters to elect our officials that can drive change. And we're seeing that in light of some of the recent Supreme Court decisions, right? So I think people need to remember that, right? Respect and agreement are not equal.
So as we close out here, I'd just like to thank our panelists and say we have a lot more to talk about. Maybe you'll come back and join us and we can dig into some of these other issues. And I greatly appreciate the information you shared with us this evening. Thank you.
Thank you.
Thank you.